Reasonable, you got them only after office hours and you can't see them, you can only see them during office hours. I think it doesn't really make sense. We just wanted to see how they are because we heard that during remand the interrogations were quite severe and there were allegations of maltreatment and torture. So we were very concerned about that, especially of course the families are also very worried because all they got was a piece of paper saying that they were arrested under the Emergency Ordinance. So as lawyers, that's our duty. We tried to do it, but we were told to come back on Monday. We immediately wrote a letter to the person in charge. We were given a name, who is Superintendent Amir, and tried to contact him to gain access immediately. We told them that we are going to come with the families today at 2 o'clock. It's office hours after lunch to try and see them. And we're going to try and see them today because we have instructions immediately to file the habeas corpus. It's something that we need to do before we can file it. And if we are not able to see them, we cannot file the habeas corpus. So we probably have to get the families to file the habeas corpus. And we hope the government will not take objections to it because the government takes very technical objections as to who affirms the affidavit. So we really have to do it. And I think we hope the police will be reasonable to give us access. Because this is, they have been remanded for 7 over days already. Whatever investigations could have occurred, they could have asked for further remand. But to use something that's so draconian like the Emergency Ordinance is quite extraordinary. And that's something that is concerning all of us. So we try and go and see them today. And if we can get instructions, we will get the affidavit affirmed by tomorrow. And we'll file it by tomorrow or Wednesday. And get an early hearing date. I think we want to say on behalf of our clients, from our instructions is that there is absolutely nothing against public order. No actions that threaten public security. I think all our clients, and some of us know them personally, are peace-loving Malaysians, rational, and will do everything according to what the law requires. So using the Emergency Ordinance in these circumstances is extremely unreasonable. It's turning Malaysia into a police state and a laughingstock of the international community. We're using laws that were meant to combat terrorism and gangsterism in 1969 in 2011. So the bar has pushed for a very long time to abolish these laws. And now you're seeing the trend because they're using the Emergency Ordinance. They don't want to use the ISA because the ISA is so well known as being something that's so draconian. But we want to say that the Emergency Ordinance has exactly the same provisions as the ISA. So if you're using an Emergency Ordinance, all you need to do is cancel the word out and just put the ISA is exactly the same. And I think it's a way for public to start gaining awareness about how draconian the Emergency Ordinance is. There are 1,000 over people in Simpang Renggam in overcrowded prisons in Johor. So the Emergency Ordinance is actually worse than the ISA. Now the ISA has less than about 10 detainees. We have 1,000 over detainees in Simpang Renggam. And if people are against the ISA, I think people should be against the EO. If the government wants to amend the ISA, the government should amend the EO as well. Who is the pegawai at Bukit Aman? Tadi kami telah berjumpa dengan Azlin yang telah memberitahu kami berkenaan status permohonan kami untuk berjumpa dengan tahanan-tahanan. Semalam kami telah menulis surat untuk berjumpa dengan tahanan hari ini bersama dengan keluarga-keluarga dan keluarga-keluarga telah datang hari ini. Dalam perbincangan tersebut kami telah memberi alasan-alasan yang kukuh mengapa kami mesti berjumpa dengan anak-anak kami di bawah Perlembagaan Persekutuan dan juga di bawah Kanun Acara Jenayah. Semua rakyat yang ditahan mempunyai hak untuk dibela oleh peguam dan peguam mesti diberi akses kepada mereka secepat mungkin. So they were brought in on Saturday, dah 2 hari dan kami juga telah memberitahu Azlin dan pihak polis bahawa they are not a threat to national security. Tak ada apa-apa bukti atau tak ada apa-apa perkara yang telah dijumpai atau keterangan yang kukuh menyatakan mereka yang ditahan adalah orang yang mengancam ketenteraman awam. Mereka sebenarnya adalah aktivis-aktivis politik dengan satu parti politik yang telah didaftarkan. Dan tahanan yang dibuat di bawah ordinan darurat adalah tahanan yang berbau politik. So we were very firm dengan pihak polis walaupun mereka cuba untuk memesra dengan kami. Kami telah membuat permohonan untuk berjumpa dengan anak guam. Pertama, kami membuat permohonan yang kukuh untuk keluarga berjumpa dengan anak guam. Nombor dua. Nombor tiga, kami meminta untuk alasan-alasan tangkapan. Dan bagi perkara alasan-alasan tangkapan, kami telah diberitahu bahawa mereka ditangkap di bawah Seksyen 31 Ordinans Darurat kerana is a threat to national security. Itu saja. Kita memohon untuk alasan spesifik tapi tidak diberitahu. Dan kami pada permintaan yang keempat, kami memohon kerana dua tahanan mempunyai kes esok di mahkamah untuk mereka boleh dibawa ke mahkamah. Dan satu tahanan kami difahamkan juga menjalani peperiksaan di sekolah. Dan kami juga memohon supaya beliau dapat menjalankan peperiksaan tersebut. So for that, they said they will go back to the superiors. We were very firm just now. Kami juga telah meminta pihak polis untuk menghubungi pegawai-pegawai IO dan pegawai-pegawai yang mengetuai siasatan untuk memberi keputusan berkenaan permintaan kami. But he said that he needs some time. So obviously to us, despite our request, despite the rights to access to counsel, the police have made up their mind even before they saw us that they will deny all rights. So we made 4 requests and all 4 requests so far has received a negative answer, and of course the last one they have to come back to us. So we have said that we will file a habeas corpus very soon. We will come back tomorrow. We will write a letter today. We will come back tomorrow at 2:30 with a commissioner of oaths for the commissioner to affirm the affidavit for the detainees. So that request has been made. And we said immediately, can you please give us an answer? They say no, we will come back to you this evening. So this evening we will know whether they'll give us access or not. But this is a continuing process of denial of access. This is something that is hindering our work as lawyers to be able to file the case in court with proper instructions. And we can anticipate that when we file the case in court, the government will say, look, it's not affirmed by the detainees. But please remember that we have tried our best, and we've been trying our best, continuing to draft the papers and continue to find ways to see them. So this is what happened today. We are extremely disappointed, but we will have to continue this struggle and continue this total blatant abuse of powers. The Emergency Ordinance is dated 1969. It is laws for the Stone Age, and is something that no civilized society like us, hoping to be a developed nation in 2020, should ever need to go through again or should ever use. So we are flabbergasted, we are unhappy, and we will have to continue fighting this through all legal processes.
So if you cannot get the detainees to sign the affidavit, so it will be considered
the family.
Technical,
They will use the technical argument, and we will have to.
For the family to sign the affidavit and file it.
Yes, families can sign the affidavit, but we must show reason why the detainee couldn't sign it. And so we have come on Saturday. They asked us to come on Monday. So first attempt Saturday denied, second attempt Monday denied. Tomorrow will probably be the final attempt with the Commissioner of Oaths. And I think 3 attempts is more than enough to show that the police are abusing their powers. Whatever they are doing is not mala fide, and it's everything smacks of a political detention. I also want to say, and a lot of people have been calling about this, the Emergency Ordinance is exactly the same as the ISA. As lawyers, we think that the government is not using the ISA because they think that using the ISA will just gather international attention, will gather immediately people will be up in arms with it. But the Emergency Ordinance is exactly the same. The powers are 60 days, ministers 2 years detention order, restriction order, and in fact currently there are 1,000 over detainees in Simpang Renggam, mostly ethnic Indians, in overcrowded and very bad conditions. And obviously the Emergency Ordinance in practice is worse than the ISA because you have fewer detainees in Kamunting. So if the government and the people want to change the ISA and get rid of the ISA, we have always been saying that you must also change and get rid of the Emergency Ordinance. We are very concerned. We are very afraid. We don't know why it's happened. Because news is during the remand that the interrogation was very severe. And that's only 7 days by the police. Now you have special branch coming in under the Emergency Ordinance, and there's a continuous historical record of people being beaten up and being tortured under the Emergency Ordinance. So we are very concerned. And we told the police, we will say this. We will say this because you don't even give us 5 minutes. We asked for half an hour, they say no. We say give us 10 minutes, no. Then we ask for 5 minutes, no. And he accepts it. The police accept it. So obviously they have made a decision not to allow access, even to see them. We also made a request whether we could just see them in a lockup to see how they are. We were also denied that. We were just taken to a meeting room to speak about it, and this is what happened. They will come back to us tonight. Our solicitor will call and check whether they will be allowed. Family access also denied.
So what exactly will they inform you tonight?
Whether we are able to see them at 2:30 tomorrow to affirm the affidavit.